and you'll note that I have the only signature on that. If we go to start with to the letter from Mr. Dr. Andy Pearce in regard to the issue of continuing on with the services of Mr. Newman and the challenges that places in front of us, the reality is we need to approve further secondment going forward to tick the boxes basically. So we've got a chief executive working for HBRC 100% of the time, and we have an interim chief executive working for us 100% of the time, and we just need to reaffirm those arrangements. So I'm happy to take any questions or even comments to kick it off, actually. And an appropriate length of time would be the first discussion. So the letter talks about, if we go to the letter from Dr. Pearce on page 31, talks about a whole range of options here, either 1 month post any BOI final decision that would require a significant change in strategic direction, or financial close, or 31st of December 2014. He regrets he cannot be any more precise about the duration of an extension, but there are matters outside the control of HBRC, obviously, that may change the course and timing of the project. So, is someone happy to open that up? You got a question or comment? Well, okay. Any questions?
One question.
Yes.
What is the chairman's recommendation?
That is a good question. I was hoping to get some feedback from my colleagues before I... Well, I would go to the 31st of December on the basis that things could change in the interim and we may be looking at something different. But at least we give some security to both our staff members of a length of time, an extension. And HBRC will certainly come back to us and say no longer required or whatever. So that would be my view. However, open to any other thoughts and suggestions.
Second question.
Yes.
Why wouldn't you go to the financial close with a right to review?
It's fine. Absolutely. It's looking at the animal from the other direction, but I'd be happy with that as well. Are you happy to move that, Councillor? Yeah, well, I'm giving you some.
I'm not allowed to make statements.
No, you're performing okay so far. Councillor Scott. Well, you move.
Well, I move that it is until the financial close with the right to review.
Sounds good. Someone happy to second that? I'm happy to second that. You wish to speak?
Mr. Chairman, I think there are several reasons why this needs to be. It's not appropriate to change horses at this stage of things, but I also think there's a very important matter of keeping separation between council and HBRC until we have actually gone through financial close. We still have, and we passed in the motion this morning on it, the provision that the Deloittes would come back to us with a final analysis. It would be inappropriate, I think, to muddy the waters by bringing the CEO back into that process before we have actually gone through that. Just to keep things clean, no conflicts of interest, no sort of muddying of the clear distinction of roles, that we keep HBRC as it is until we've reached that point, we keep council as it is until we reach that point. So I think it's quite important on two prongs. One, to give continuity through to HBRC. Secondly, to keep our decision making absolutely transparent and clean.
Thank you. I'll reserve my right to speak. Councillor Barkey wishes to speak.
I support that. I think there's a clear line in the sand. Financial close, we're going to know whether the project is going to be run or not. If not prior to that, it seems to me that the having the staff and the current arrangement as is eminently suitable to that. If we get to the point of financial close and there needs to be some ongoing commitment in this regard, well, then we'll be in a position to know that. We're only going to second guess at this point. I accept your contention that staff need clarity about it between now and then. I agree with that. I would be reluctant to have supported 31st of December. It's just I think my Scots upbringing a little bit. Be very cautious in that had we agreed on the 31st of December, it could have been August all finished, and we've said to people, well, they can have a holiday till the 31st of December. Well, I like people working, you know. I wouldn't want to see Liz have to carry the job while someone else is on full pay till the 31st of December. So I'm happy with the financial close.
Thank you. Other speakers? Wish to sum up? I'm happy not to speak. Thank you. I'll put that motion. All those in favour, please say aye. Contrary, no. Carried. Councillor Beaven's notice of motion. So you need a seconder, and I'll indicate right now I'm prepared to second it. So you wish to move it?
Yes, I'll move it.
And I'm happy to second. Okay. I just remind councillors that the discussion is around this particular piece here. I'm not prepared to go into the red paper component of it, although I think I can cover the issues that have been raised with me directly in my my part of the debate. So I'm happy with that.
Okay.
So
Point of order. I think this is an unusual thing.
it is unusual.
That you have seconded, not that you have seconded it, but that you have views on what can or cannot be said. And I would think that would be really helpful to the debate if you went first, outlined all the things that you think people want to be covered, and then we've got clarity about that rather than people wait to find it out secondly.
No, I disagree on the basis of it's Councillor Beaven's notice of motion.
Sure, right.
I'm just talking about the confidential nature of the particulars of that piece of work that Councillor Beaven brings up.
And I'm mindful of that too, Chair,
Yeah, and
have spent some time considering how I can present this without delving into the public excluded elements that it potentially could involve. So, stop me if you think I'm straying. Any organisation, in my view, needs as much information at its disposal as possible to inform good decision making. The public have a right to expect it, and we have a duty to deliver on it. So it was very disappointing to me to discover that some what I regard as highly relevant facts after we had had a discussion and decision on the CE salary in January this year. So I want to outline what those facts were. The Chief Executive, Andrew Newman, was appointed to work full-time for HBRC on July 1 last year, and Liz took over as acting CEO. In a public excluded meeting on September 25th, the previous council received an independent assessment of the CE performance and made a salary adjustment. Only 3 councillors who made that decision were still present in January. Around the same time, those same 3 councillors, in their capacity as directors of HBRC, discussed the salary of their new CEO. It was agreed to make a recommendation on it to the regional council, who was still his employer. However, by the time the recommendation actually came before the regional council in January, those 3 councillors had resigned as directors of HBRC. So, technically, the recommendation did not come from them. But they had previously discussed it and agreed on the recommendation that we received. The regional council agreed in a second public excluded meeting in January to increase his salary by 30% to $380,000. That's in the public domain, so I can say what happened. Now, I'm not discussing the merits of that wage increase. Others might choose to do so, but I'm addressing the flaws in our process. So I have 2 major problems with the process. The fact that 3 councillors did not notify the 6 new councillors of that public excluded discussion and salary adjustment in September. I know that the response will be that the January discussion was a higher duties allowance and was therefore not relevant. That argument for me is disingenuous. How could a salary increase and performance discussion that was only 4 months previously not be relevant? So that's the first thing. The second thing, There was no declaration of the previous discussion that the three councillors had as HBRC directors on this matter. In my view, at the very least, there was a perception of predetermination on their part. And I want to refer you to the elected members' governance handbook, and I want to read to you the piece that deals with these matters. And this is what it says. There are legal rules about conflicts of interest more generally which apply to non-pecuniary conflicts of interest. These include the common law rule about bias. To determine if bias exists, consider this question. Is there a real danger of bias on the part of the members of the decision-making body in the sense that he or she might have unfairly regarded with favour or disfavour the case of a party to the issue under consideration? The question is not limited to the actual bias, but relates to the appearance or possibility of bias. This is in line with the principle that justice should not only be done, but should be seen to be done. Whether or not you believe that you are unbiased is irrelevant. Now, in my view, there certainly was a perception that there could have been a bias or a predetermination, if you like. So I'm raising this matter because I've been greatly troubled by the process that we adopted. I feel it was wrong, I feel it was very poorly informed, and I think we can do a lot better, and we need to do a lot better in the future. So what I want this council to agree is to write an extra rule into our code of conduct that if anyone appointed by this council to a position in any organisation other than one of our own subcommittees will not vote when any matter affecting that organisation comes before us. So I'm looking to try and get agreement that we should make that change for the future to avoid this situation.
And we can deal with that change in the future, but you notice the motion is pretty clear in what it says here today. As seconder of this, I'm happy to have my say, and I'll encourage others to have their say. It's been interesting, the level of concern over this matter. For instance, no one has said to me, you didn't tell us what the previous discussion looked like, or the one before that, or the one before that. I mean, how far back do you go? The chief executive of these organisations live in a constant place of, I was going to say regeneration, but it's not that. A constant pace of review, as it were. And be aware, Councillor Beaven, you do have the right of reply at the end of this. To make such a claim that it was withheld or was not made plain, I find a little hard to swallow on the basis that all of us, when we come into these organisations, are required to do some due diligence. After that particular meeting, the papers were made available to you. All the red papers are available. There are some challenges there with, in this particular instance, because it is part of a contract negotiation ongoing with our Chief Executive, and that is a discussion for the Chief Executive to have with us directly, and we all accept that. But the challenge that you've put to us, or put to me personally, and I'm happy to take this on the chin, if we can do it better going forward, that's fine. But I don't expect to have to spoon feed everyone along the way. So I'll throw that back, actually. You had ample time to do any amount of due diligence that you felt was required to help you make a judgment on that decision. To come back and say HBRC making the recommendation is disingenuous, well, that's a fact. They came in with the recommendation. They weren't concerned how we got to the previous level, and we're not. You can talk about percentages and things, but actually the notice of motion is quite clear in what it says, and I agree with what you're saying. You were not given that information because at the time, even though my signature was on both documents, and I'll make that quite plainly as well, it was not relevant to HBRC's desire to increase the salary in the form of a higher duties allowance to the Chief Executive. They are the ones monitoring his performance. They are, in effect, his governors at the moment. We would have very little opportunity to assess the job he's doing for them because actually we don't deal with him day to day. the claim that councillors came in with a bias for predetermination, I actually don't buy that. The simple fact is a new set of governors that replaced us went through the discussion with HBRC and suggested that that person needed to be topped up to a remuneration commensurate with the work that he was doing at the time. Whether people agree with that or disagree, that's beside the point. I don't think the extra piece of information would have made the difference that you are claiming it would have made to that decision. And that's my view, and I stand by it. Ultimately, HBRC has a few chores to do. They have to decide a whole lot of issues around their employee at the moment. Even though officially he's from us, he is in effect their employee at the moment. He answers to the board and he answers to the chairman of HBRC. Ultimately, going forward, he will come back to us. The irony in all this, of course, and it's not an irony, but it is a fact. I mean, we don't interfere with the setting of the remuneration for the chief executive of the port, for example, and nor should we. In this instance, if Mr Newman was not our employee but was actually employed directly by HBRC, we would have read about whatever in the annual report. So going forward, I take it on the chin. I'm pleased that this is directed more so at me than at the employee, and I accept the criticism. I don't accept the methodology around it, but I'm pleased you brought it up, and I'm pleased we're having this debate.